Drink driving cases dismissed. Yeah, that's an interesting one. One of the, I suppose, the main way that we imagine in our own heads a case being dismissed is where the evidence is heard from the prosecution, the evidence is heard from the defence, and the judge finds that the evidence of the prosecution wasn't compelling enough and strikes the case out. That's the view most people have. But there's other ways why a case might be dismissed. Yes, the prosecution evidence mightn't be very strong, or the judge might have a doubt about the prosecution evidence, but there's other ways too where a case might be dismissed. Maybe the case was fixed for hearing and a vital piece of documentary evidence goes missing or is not in court. A vital piece of evidence wasn't given to the court, said in testimony, or a vital witness may not have turned up to court. And any one of those things can trigger an automatic strikeout of the case if one of those things is seen by the court to be a very vital aspect of the prosecution case. So there's many different ways why a case might be dismissed. Can you still drive after being charged with drink driving? Yes, you can. You're entitled to drive your car up to the point where you're either found guilty of drink driving by a court or you plead guilty to drink driving in court. Court is the operative word here. Only a court can find you guilty, and an insurance company can't, for instance. So you're entitled to drive your car until you either plead guilty to drink driving or have been found guilty of drink driving, and that the difference in time between arrest and being found guilty or pleading guilty can sometimes be weeks, but it can also be many, many months. So you're entitled to drive until the court finds you guilty and imposes a disqualification on you, yes. Drink driving technicalities, Ireland. Okay, the first thing you need to understand about that expression, drink driving technicalities, is that there is no such thing as a technicality. That's a made-up term that the media use to talk about drink driving, or if people are acquitted of drink driving. There is no such thing as a technicality. There is just a law, and the guards must follow the lawful procedures that's laid out in the law. And if they don't follow those procedures, a court can find the case not proven. That's not a technicality. That's just the court admitting or asserting that the law wasn't followed correctly. So there's no technicality, there's no loophole. That's another word that's made up. That's not actually true. There's no loophole. There's just a law. So that's all that it is. And when the law is not followed properly, a case can be dismissed. But it's not a technicality and it's not a loophole. It's just that the law wasn't followed. That's what that means. How to appeal a drink driving ban in Ireland? Well, if you've been found guilty by the district court of drink driving, you can then at that point in court file a notice of appeal. You can appeal the disqualification decision by the district court there and then in court. And when the proper appeal papers are filled out and properly lodged, you'll get a copy back from the court clerk, and that will indicate that your appeal is lodged. You're entitled to drive during that period until the appeal comes up. But the appeal is held now in the circuit court, which is a higher court, and they will rehear the case all over again from start to finish. And if you're successful then your appeal will be successful and the disqualification will be removed, obviously. But if it's not successful, then the decision of the lower court will remain. That's how an appeal works in drink driving cases.